Well, when more than one person buys a property together, then they need to state on the land registry form in what capacity they're going to hold it. And it'll ask you in joint, whether it's a joint tenancy or a tenancy in common or some form of trust, and that's where you say it. It may not suit you to be joint tenants, particularly say if people are buying a property, might be friends starting out. They want to make sure that their individual shares are represented. They may have contributed to the deposit in unequal amounts. They may be paying the mortgage in unequal amounts. That ought to be reflected. And these decisions need to be made right at the outset rather than halfway through, because then it's very hard to unravel it. So start off, go and see a lawyer, state what you want to do, and he'll set out a document, a trust document, which will give the proportions that you should be owning the property. You frequently have different shares, different proportions in tenancy in common. A situation where a tenancy in common is mostly encountered will be where you have a partnership or a joint venture. You will find that parties are contributing to the project in different proportions, and quite naturally they want that reflected in the degree of ownership they have. And so you might have someone owning 60%, another 40%, or if there are more parties, well, as many proportions as you like, really. I strongly recommend you see a solicitor to draft a declaration of trust, set out exactly what you want, what the property is for, and what shares you're going to own it in. That way, if there's any dispute in the future, it's already been settled. It's already set down. Good fences make good neighbours, I think.